terms of services.
Thank you very much. Sorry. Thank you very much, Mr. Raphael Wambua, for the brief introduction. Before we go to the composition, let us also first introduce the other panelists. Thank you. Dr. Jackson Bett, who is the chairperson of Micro and Small Enterprises Tribunal. Welcome. The floor is yours.
Good afternoon, everyone.
Good afternoon.
Yeah, my name is Jackson Bett. I chair the Micro and Small Enterprises Tribunal. Thank you.
Thank you very much, Dr. Jackson Bett. And now, Ms. Dorothy Jamato, the floor is yours.
Thank you, Teresia. My name, first of all, good afternoon, all the members. My name is Dorothy. Yes, my name is Dorothy Jamator. I'm a member of the Energy and Petroleum Tribunal. And yes, we will discuss as we go along.
Thank you very much for the introduction. Yes, members, you've heard it for the panelists. That is Mr. Raphael Wambua, a member of the Legal Education Appeals Tribunal, Dr. Jackson Bett, who's the chairperson of the Micro and Small Enterprises Tribunal, and Ms. Dorothy Jamato, who's also a member of the Energy and Petroleum Tribunal. With no further ado, now we're going to kick off and ask Ms. Dorothy Jamato to give us a brief history of the tribunal, when it was commenced, and how it works generally. Thank you.
Okay. I guess probably we are among the youngest tribunals in the country. This is based on the fact that our tribunal was established by Section 25 of the Energy Act, and that's the Energy Act of 2019. We did have an energy tribunal in the previous act, but once the 2019 act came into place, we now had a new tribunal called the Energy and Petroleum Tribunal. So the Energy and Petroleum Tribunal, before the 2019 act, we had the Energy Tribunal, but after the act, we had the Energy and Petroleum Tribunal. The composition, Teresia, should I go there? The composition of the tribunal is that we have 7 members. 2 members are experts in the energy sector. So we have 2 engineers amongst us. Then we have a chair and a vice chair, both of whom are advocates of the qualifications of a High Court judge. And then we have 3 other advocates, and that makes it a total of 7. The current chair is Senior Counsel Kyoko Kulikumi, and our vice chair is Doris Mirigi. I don't know whether she's attending today's session. She wanted to be part of us so that she could learn. Then the other advocates are Faisal and Sami Maina. Yeah, thank you.
Thank you very much, Ms. Dorothy Jamator. That was quite an introductory. And now to Mr. Jackson Bett. Please tell us about a brief history of when your tribunal commenced, how long it has been there, because now we have known that the Energy and Petroleum Tribunal is one of the youngest tribunal. So let us also know when the Micro and Small Enterprises Tribunal was commenced, and how it works, and also the component of the members of the tribunal. Thank you.
Okay, so thank you very much, Teresia. So the Micro and Small Enterprises Tribunal is a tribunal that is established under the Micro and Small Enterprises Act number 55 of 2012. Now, despite the fact that the act was established the act was enacted in 2012, it was not until the year 2018 when the Micro and Small Enterprises Tribunal was established. Initially, it was established on an interim basis, and in the year 2020, the current tribunal was duly established. So as it is right now, the tribunal has been operational from the year 2020 fully. But before then, the in the year 2018, the tribunal commenced operations, but at that particular time, there was no substantive chairperson. But in the year 2020, we had the current tribunal. Now, in terms of composition of the tribunal, the same is provided for, again, within the provisions of the Micro and Small Enterprises Act, Section 55 of the Act. We have 7 members. We have the chairperson and the vice chairperson who are advocates, and their qualifications of the chairperson as well as the vice chair are that of a judge of the High Court. The chairperson and the vice chair are nominated by the Judicial Service Commission, but appointed by the cabinet secretary, in charge of the micro and small enterprises. We also have an advocate of the High Court who should have 7 years standing at least. And we also have 2 advocates who should be well versed on matters relating to the micro and small enterprises. And we also have 2 other members who are not advocates, but have competencies insofar as the management of the micro and small enterprises are concerned. So as it is right now, we have 5 members, the chairperson. We also have our vice chair, Mr. Robert Katina. We have Honorable Were, who is a member of the tribunal. We have Annette Gikuya, who is also a member. And we also have a representative of the business industry, that is Alvin Kibet. So basically that is it insofar as the tribunal is concerned. And I think it has to be stated that the idea was to have a tribunal that would deal with all these matters, the disputes relating to the micro and small enterprises, which are actually vast. I think we all know that the micro and small enterprises perform a very, very important role in the economic development of the country. And to that extent, therefore, we as a tribunal are privileged, to be part of that contribution. Thank you very much.
Thank you very much, Dr. Bett. Now the floor is Mr. Raphael Ombua. Please give us the honor of giving us a brief history of your tribunal, how it started, the composition of the tribunal, and why we should approach the tribunal.
Thank you. The tribunal, as I had already mentioned, is established under the Legal Education Act, number 27 of 2012. The tribunal was constituted by the Judicial Service Commission in the year 2013. However, it did not commence operations until the year 2018, when members and the chairperson were gazetted. In terms of the statutory composition, the tribunal consists of a chairperson and 4 members, together with the registrar. The chairperson ought to be a legal practitioner of not less than 10 years standing, or a person of a distinguished, a person who has distinguished himself in the field of legal education for a period of not less than 10 years. And then there is 1 member who should be an advocate of not less than 7 years standing, or one who has distinguished himself or herself in the field of legal education in terms of academics. The other 3 members who must have demonstrated legal competence in the field of legal education, and the registrar, who is an advocate of not less than 5 years standing. Maybe just to repeat, the current chair is Honorable Rose Waithera-Mbanya. Is Mrs. Eunice Arwa. There is Mr. Stephen Gitonga. Mr. Stephen Gitonga. And the registrar is currently is Mr. Gilbert Onyango. In terms of the seat of the tribunal is based at Kolodha House. The tribunal is not full-time. It sits on an ad hoc basis based on when appeals are lodged or references are made to it for consideration. Believe in terms of services, we will discuss what we deal with shortly.
Thank you very much, Mr. Raphael Lombua, for that brief introduction. And when we will make sure we are going to be more audible for all the members to be able to hear us. Dr. Bet, you have mentioned that your tribunal deals with most micro and small enterprises. Why should an advocate or any member of the public out there approach the micro and small enterprise tribunal instead of the small claims court?
Thank you very much, Teresia. So the tribunal, as I have indicated, has the benefit of the diversity in terms of membership. You can clearly see that we have 7 members. We have experts within the industry. And to that extent, therefore, I think that diversity clearly demonstrates that the tribunal would be better placed to address, the specific, matters relating to the challenges within the industry. The second advantage that we see, in so far as our tribunal is concerned, is the cost component, because as it is, for a long time we did not charge, for the filing fee, so that members of the public who would approach the tribunal with their matters, they would actually file the same without the requirement of filing fee. But as it is, under the gazetted guidelines, we are introducing the filing fee. Now, the other benefit that we see insofar as the tribunal is concerned is that we are not so much, and this is a statutory provision, that the tribunal should not be so much fixated with rules relating to procedure as well as rules relating to evidence. And that explains the reason why, we don't rely so much on the provisions under the Evidence Act, Chapter 80. So to that extent, therefore, we are flexible as a tribunal, and a number of times we entertain, claims that may not really fit within the pleadings, as we know within the provisions of the Civil Procedure Rules as well as the Civil Procedure Act. So to that extent, therefore, I think that level of flexibility is another benefit that you can get from the tribunal. The other one is the expeditious disposal of disputes. For the 2 years that the tribunal has been, the current tribunal has been in office, we have managed to deal with matters within the shortest time possible. And when I talk of, the time period that we normally take insofar as determination of disputes is less than 60 days. So to that extent, therefore, I think you can clearly see that we try as much as possible to dispense with our matters expeditiously. I think maybe one or two matters have extended beyond the 60-day period. So I think that is another positive development that you can clearly derive from the tribunal. So indeed, there are quite a number of positives that the members of the public would have insofar as the approach to the tribunal is concerned. Now, so that I don't forget, I think we are also flexible insofar as our operational scope is concerned. So that if, for instance, a matter is filed in Kisumu, it is the tribunal that moves to Kisumu so as to dispense with such a matter. So we actually move to the exact location where the matter has been filed. So I think that is another positive development. Now, let me also, because you've alluded to the small claims court, I think it's important to delineate, the functions of these two institutions. When you look at the jurisdiction of the small claims court vis-a-vis the jurisdiction of the micro and small enterprises tribunal, you find that there are quite a number of issues that the micro and small enterprises tribunal would deal with, of course, corresponding limitation under the small claims court. And I think shortly we will be looking at issues relating to jurisdiction. But just to say that there would be one or maybe one or two areas of convergence, but the areas of divergence insofar as jurisdiction is concerned would be vast. And I think we'll demonstrate the same shortly. Thank you.
Thank you very much, Dr. Bet. Jamator, in your tribunal, Dr. Bet has told us they are very flexible. They are not really sticklers of what the law provides. Can you please tell us about the Energy and Petroleum Tribunal? If I come and file a matter there, how long will it take? What am I supposed to do? How am I supposed to approach your tribunal? What kind of pleadings am I supposed to file before the tribunal? Thank you.
Thank you. We are more or less quasi-judicial. We are a quasi-judicial body, so we are not. We don't look into the strict rules of procedure per se. But in the Energy and Petroleum Tribunal, you can move the tribunal in two ways. One, based on our jurisdiction, you can file an appeal from the decision of the authority, or you can file a substantive statement of claim if you're trying to exercise our original civil jurisdiction on matters touching on licensees and third parties. So you can have the appeal filed, or you can file by way of a statement of claim. Then more often than not, most of our appeals or statement of claims are filed under certificate of urgency. And once a party does that, we ordinarily mention that matter the very next day that we have our sittings. So it essentially means that once you file your matter, chances are you might be heard the next day, whereby we will give you directions. This has really assisted the tribunal in trying to fast track all its matters, and the ease of hearing our matters has helped us close most of our files in 1.5 months. So the minute you file, say, your case on a Tuesday, the matter will be mentioned on Wednesday. Parties are given directions on filing of submissions, and if at all it's a matter where you don't need to call witnesses, and thereafter we give you a ruling date. After parties have filed their submissions, we usually give our rulings after 14 days, after confirming that the parties have filed their submissions. So we are a pretty fast tribunal. And All our pleadings are filed virtually, so we don't take any physical copies. The hearings are conducted virtually as well, so we hear our parties virtually. We sit at forodha, that is, if at all we are to hear a party physically by way of, calling witnesses and having the cross-examination being conducted, but that is at the request or with the agreement or consent by the parties. But essentially, that's how the tribunal operates. Everything is virtual. Decisions will be read out virtually, and you will get your typed ruling posted in the system. So I would say the tribunal is more or less 100% electronic. We have transitioned to operating virtually. We don't really, we are not very strict on rules of procedure. We, however, would also take into account the aspects of rules of natural justice. So we are not that flexible to just operate as though we are a kangaroo court, but at the same time, we try to be as balanced as we can and as flexible as we can. And yes, that is how the tribunal operates. I don't know whether I have left anything out, Teresia, because I think the other thing that we talk about is the aspect of jurisdiction, which would take quite some time because our jurisdiction is a bit complex. Thank you.
Thank you very much. You've just left one thing. When one is approaching a tribunal, what kind of pleadings do you approach the tribunal using?
Yes, I had said you approach it you have two ways of approaching the tribunal based on our jurisdiction. So you can file an appeal, you file a notice of appeal and a record of appeal from the decision of the authority or the regulator, which is the Energy and Petroleum Regulatory Authority. Or you can file a statement of claim, which is when you're challenging when you're exercising our civil or regional jurisdiction in a dispute touching on probably licensees or a licensee and a third party. So you can move the court, or you can move the tribunal in both ways. And more often than not, in both instances, parties have been approaching us by way of certificate of urgency with an application asking for certain injunctions or stay orders. So more often than not, they will file a certificate, but you have two options that are available to you.
Thank you. And are you also flexible like the micro enterprise tribunal, whereby if a layman out there wants to approach you and they do not understand how to draft a record of appeal or a statement of claim, will you still hear them out?
Yes, we actually have, so far, I think we have currently 3 or 2 cases that have been filed by individuals. And yes, we are very flexible in terms of the pleading, so long as we can understand the nature of the dispute and the claim is in a properly structured way. We do not send away our clients. We will definitely assist the client at the time of filing their pleadings. The Secretariat would always assist them to ensure that their issues are well captured in their statement of claim or in their appeal. So we are not very strict in terms of you must follow a certain format. And I need to add at this point that we are yet to develop our rules, and that's why you're seeing we are having this type of flexibility. We have, since the previous rules were under the old act, and that act, a lot has changed, including our mandate and the jurisdiction. We are developing new rules that will help the public and of course counsel to understand how they can file matters before us and how they can move the tribunal. So that's what we are working on. But at the moment, you can move the tribunal in the manner that you feel is most suitable, so long as you can bring out your issues in a clear and concise way. We will hear you.
Thank you very much, Ms. Jamato. To Mr. Raphael Wambua, how does one approach your tribunal? And are you also flexible when it comes to people who do not understand, especially the laymen, how to approach tribunals? Are you going to be flexible to receive their pleadings and advice, or will you cut them out?
In terms of procedure of filing, the rules of the tribunal are still underway. We have now passed the public participation stage. We are waiting just some few formalities to be completed in terms of the statutory. If you have lodged a memorandum of appeal or you have put your appeal in writing, since there are no strict rules of procedure, flexibility is allowed in terms of presenting your grievance to the tribunal. What matters most is the supporting evidence in terms of documentation that one presents to the tribunal. Once that is captured, the appeal is good to be heard and the relief that one seeks. In terms of access to the tribunal adopts the electronic filing version, whereby to present an appeal, memorandum of appeal, you're charged 1,500 shillings. The tribunal proceeds mostly by way of written submissions with the option of highlighting being accorded to the parties, and they are accorded an opportunity should they also wish to waive the same to inform the tribunal. The parties are also at liberty to proceed through oral evidence, whereby you can call witnesses to deal with your appeal. In terms of timelines, the tribunal is able to dispose of matters within at times as fast as 2 weeks, and mostly it spans to a maximum of around 60 days. In terms of representation before the tribunal, a party can appear through an advocate or in person or through any other person that the tribunal would deem fit to accord audience on behalf of an appellant. The tribunal also deals with references attended by the Council for Legal Education on matters that it seeks clarity from it. I believe the decisions of the tribunal are embodied in judgments, where you can get a formal decree extracted for purposes of execution. Yeah, that is all for that session.
Thank you very much, Mr. Rafai. Well, I'll take this next question to Dr. Beth. So when you're filing or approaching the micro or small enterprise tribunal, how much is one supposed to have, or is it free?
Thank you, Teresia. As I indicated earlier, previously before the gazettement of the rules, I think towards the end of last year, there were no charges. So the litigants would file matters free of charge. But with the gazettement of the new guidelines, the fee applicable is 1,500, and that is standard.
Thank you very much, Dr. Beth. I'll pose the same question to Ms. Jamator and also to Mr. Wambua. How much is one supposed to have before they approach your tribunals so that they can file their pleadings?
Yeah, so for the Energy and Petroleum Tribunal, the filing fees are also as minimal. At the moment, I am informed that the filing fees is about 1,000. But since we are looking at our rules, we might be in a position to review it, take into account the value of the subject matter and the nature of the complaints that the tribunal has been handling. But at the moment, it is 1,000.
Yes, to file an appeal is 1,500 shillings. Currently, in the draft rules, there is a provision whereby we intend to deal with waiver of court fees based on considerations to be made by the tribunal, so that people are not denied access to justice due to lack of the fee. But for now, it's 1,500 shillings.
Thank you very much for that. I will pose this next question to all the three panelists. I will start with Dr. Bett. So how long does it take for a matter to be filed and the final adjudication before your tribunal?
Well, for the matters that we've dealt with, and actually there are numerous matters that we've dealt with, the period has been less than 60 days. We've had instances when we've managed to dispose of matters within a shorter period than that. But as I mentioned earlier, I think we've had two matters that have spilled over beyond the 60-day period. Now, let me just state this, that insofar as the tribunal operations are concerned, before the advent of COVID-19, we had all our matters physically. And also, that was also informed by the fact that the kind of clientele, majority of the clientele that we were dealing with, we assumed at that particular time that they are not well informed on matters relating to technology and so on and so forth. And during the advent of COVID period, we had to take a decisive move. And that is when we realized that indeed it is actually possible for anyone to reach the tribunal. So we rolled out, the virtual tribunal sessions, and we in situations where the members of the public were not able to, did not have the technological know-how, we improvised innovative ways where the members of the public or the litigants would visit the nearest court station, and we made arrangements with the registries of those court stations so that they facilitated the members of the public to have virtual sessions with the tribunal. So to that extent, therefore, I must say that we've fully embraced technology. The filing is either by way of email. It can also be filed physically, but we also have, the e-filing system. So ours is a blended kind of framework. But all in all, the maximum period that we have, inculcated within ourselves as a tribunal, and that is provided for, within our rules, is 90 days. But we try as much as possible internally to deal with the matters within the 60-day period. Thank you.
Thank you very much, Dr. Bet. I'll pose the same question to Ms. Jamator and Mr. Wambua.
I think I'd mentioned earlier that it takes us 45 days. A majority of the matters that have been filed before us at the point of an appellant or a claimant filing their appeal or claim, we give the respondent 14 days to file their response. Then after that, parties exchange their submissions within 14 days each. And then we give our decision after 14 days. So more or less, it takes us to about 45 days from the time of filing the dispute. In other instances,
Sorry. Does that mean in extraneous circumstances, you cannot extend your timelines?
We do extend timelines when we have at the request of parties. Sometimes parties would say they have not yet gotten instructions from the clients, or they are not yet been served. So we tried, of course, with the concurrence of the other party, but we do not give long extensions. We try to, or adjournments. We try to limit the time to at most 14 days or 7 days. We can't give you more than that. Then we also have matters where parties want to call witnesses. Those ones will definitely exceed the 45 days because now parties are not exchanging submissions, but agreeing on a hearing date. So when that happens, the 45-day window, of course, will be crossed, or you will pass it. Then in certain instances, we have also had matters on the spot where you can file a matter under certificate of urgency, but as a tribunal, once we go through the matter, we note that we don't have jurisdiction. We have been giving rulings on the spot, referring that matter to the necessary institution so that we don't waste the time of our litigants. So it depends on the nature of the dispute. And that's why we could do as short as 1 day. You can file today, then tomorrow you are referred to probably the regulator, or you can file today and after 45 days you get your decision, or in certain instances you can file today and you can be waiting for probably 2 or 3 months as we try to sort out the issues of a hearing date. So it really depends on the parties, and it also depends on the nature of the dispute. Thank you.
Thank you very much, Ms. Jamato, on that. Mr. Wambua?
Yes, normally the time span of disposal of appeals is between, as I said earlier, 2 weeks to 60 days. 60 days being the upper limit in terms of practice as a tribunal. In most cases, we are ready to dispose of business as fast as possible. However, we encounter challenges of the parties not being ready, but we discourage the practice of adjournment so that we don't have a backlog of matters. For matters under certificate of urgency, we are able to consider the same in terms of directions within 24 hours to 3 days. There are times when we have even had appeals within a maximum of 1.5 weeks and delivered judgment within, actually disposed of the entire appeal within a period of 2.5 weeks. Yes, that is it.
Thank you very much. Members, as we are almost coming to the end of the session, please pose your question on the comment section or on the chat section so that we'll be able to ask our panelists. Well, I'm going to start with Ms. Jamator. Does one need an advocate or to be represented before your tribunal, or can just any member come before your tribunal without representation by an advocate?
You don't need an advocate. I think we've had 3 matters where I think I've mentioned the parties are representing themselves, and the litigants have actually done a very good job because they have taken the time to study the nature of the complaint. and decisions have been rendered depending on the facts that were before us. And so for us, we are open to either you can come with counsel or you can just represent yourself. It really doesn't matter, because either way, we will try to accommodate anyone who appears before us.
Thank you very much, Ms. Jamator. Dr. Bet, can I come on my own individual position as a layman, or do I need an advocate to be represented, or does your tribunal mostly have members who just come on their own volition without advocates representing them?
Thank you. So when you look at the provisions of the Act, it is it's permissive in the sense that the members of the public can approach the tribunal on their own, but they can also be represented by advocates. Now, the experience that we've had is that a number of times, most of the matters that are handled by, where the members of the public are self-representing, tend to take a shorter period. But those matters where we have advocates representing, I think we've noted that the period actually is slightly longer. So I think that is an issue that can be well addressed, and we try as much as possible, to advise the advocates not to be carried away, so that we just focus on the issues, and we try as much as possible not just to determine the case, but to have an actual resolution of the dispute. So to answer you, I think the law is actually permissive.
Thank you very much, Dr. Bet. Mr. Wambua, is also the law permissive in your tribunal, or are you strict to that members need to be represented by an advocate?
Yeah, the statute establishing the tribunal at section 33(1) of the Legal Education Act allows one to be represented by an advocate or any other person whom the tribunal may grant permission to act on behalf of an appellant before the tribunal. We are yet to encounter a case whereby a person has sought to be represented by one who is not an advocate. But however, should the case arise, we believe we'll exercise the requisite flexibility. After all, it's all about access to justice.
Thank you very much. Before we go to the members' question, what opportunities? Dr. Bet had told us why go before his tribunal and not go before the small claim or the magistrate court. So I'm posing this question to Ms. Jamator and Mr. Raphael Wambua. Why come before your tribunal and not any other place to seek redress?
Is that me? Should I go?
Yes, please. Yes, please.
Okay, so why come to the Energy and Petroleum Tribunal? Was that the question?
Yes, that was the question.
Yes. Okay. It's a pretty good question, which I have seen quite a number of our members have been grappling with. We are a specialized quasi-judicial body, specialized in the sense that we handle disputes within the energy and petroleum sector. And this specialization has enabled parties to have their issues addressed with depth, based on the experience by the members who sit in this tribunal, and of course, pursuant to what the law provides. And the expertise and both academic and experience will assist litigants to have their issues resolved, which would be quite difficult if a party would go directly to a court of law, whereby that expertise in certain matters would be limited. And when I say certain matters, I would give you examples of where questions of meter readings come into play. How do you distinguish what is what? How do you get to know that this particular formula is what is to be applied when, for example, looking at the price of fuel and things like that. So the Energy and Petroleum Tribunal is a very good forum to handle complex disputes of a specialized nature and very much related to the energy and petroleum sector. That is why members come, or rather why litigants come to the Energy and Petroleum Tribunal. I don't know whether I should address the other questions that have been posed by the members, or we will have another session to go through them.
The questions we're going to start in the next few.
Okay, that's fine. Thank you.
Yes. Mr. Wambua, why will anyone come before your tribunal and not go file maybe a petition or any other application before the court?
There are reasons for the same. First of all, there is the doctrine of exhaustion of statutory remedies. In that, first of all, some disputes are mandatorily required to be heard by the tribunal in terms of its jurisdiction to address appeals from decisions of the Council for Legal Education. You'll find that in some cases, if you move to the High Court, the judges will refrain from exercising jurisdiction and refer the dispute to the tribunal. And then in terms of other considerations that arise in terms of time of decision making, the tribunal is much faster because it is a specialized one, whereby it just deals with the disputes on legal education. So it does not deal with other matters that the ordinary courts would be logged with in the course of disposal of their mandate. Number two, there is a cost. The cost of access to justice is lower compared to the courts. And then there is flexibility with the tribunal in that procedures are kept to a minimum, with the tribunal being mandated by the law to regulate its own procedure. And then the tribunal is more accessible in terms of justice, okay? In terms of filing procedures, and also in terms of decision making.
Thank you very much for that, Mr. Wambua. I will start with a question that was posed in the chat group by Mr. Jojita Congo. I will start with Dr. Bett. Please, in brief, elucidate about your jurisdiction.
Thank you very much. So, for us to understand the jurisdiction of the tribunal, I think it's important to consider the definitive elements. And there are two issues that need to be considered. First of all, what is a micro enterprise? And secondly, what is a small enterprise? Because our jurisdiction revolves around the micro enterprises and small enterprises. And I think I mentioned earlier on that the convergence between the Small Claims Court and the Micro and Small Enterprises Tribunal is actually dependent on the statutory provisions. Now, in so far as a micro enterprise is concerned, generally, I mean, it is a business, entity that is defined insofar as the membership is concerned, and it has, less than 10 members. But and the annual capacity of the micro enterprise is not more than 500,000 shillings. But the capital enterprise of a micro enterprise is also dependent, so that if, for instance, you're dealing with a service sector, the capital portfolio should not be more than 10 million shillings. But if it is, actually that is a manufacturing sector. But if you're dealing with a service sector, it should not exceed, 5 million shillings. So I think you can clearly see that in itself marks a point of departure, because with a small claims court, the nature of claim, or rather the claim, should not exceed 1 million shillings. Depending on the gazetted, jurisdiction. But insofar as a small enterprise is concerned, the number of membership should not be more than 50. The annual turnover is not more than 5 million shillings, between 500,000 to 5 million shillings. But the capital enterprise, if you're dealing with a service industry, it should not be more than 20 million shillings, between 5 million and 20 million shillings. And within the manufacturing industry, it should be between 10 million shillings and 50 million shillings. Again, that is a point of departure, because you can clearly see that we're dealing with a capital investment and not just a claim, a monetary claim. Now, insofar as jurisdiction proper is concerned, I think it should be possible to look at it in 3 levels, so that we have 3 subjects. We have the enterprises, micro and small enterprises. We have the associations, which define the conglomerate of numerous, actually not more than 35 micro and small enterprises. But we also have the authority, the Micro and Small Enterprises Authority. So jurisdiction of the tribunal is really dependent on the overage that, or rather transgressions that may occur in relation to the 3 subjects that I've just mentioned: micro enterprises, micro and small enterprises, the associations, as well as the authority. So that if, for instance, there is a dispute between the members, the past members, and even the deceased members of the micro enterprise amongst themselves, then the dispute would be presented before the tribunal. And the same would also apply in relation to the micro and small enterprises vis-a-vis the associations on the one hand, but we also have disputes between the associations and the authority. The third layer would be the disputes between the micro enterprises and the authority. So you can clearly see the different layers. Now, insofar as the specific items relating to the dispute, we have diverse kind of disputes that can be presented before the tribunal. We have commercial disputes, which may involve the micro and small enterprises. And of course, this would actually provide some convergence between the micro and small enterprise and the small claims court, insofar as commercial disputes of monetary nature are concerned. But you can as well distinguish the same by looking at the capital portfolio, so that if the capital enterprise is more than 1 million shillings, and I think it would be beyond the jurisdiction of the small claims court. Now, the second kind of dispute that would be presented before the tribunal would be disputes relating to compliance of rules and regulations relating to allocation of work sites. Now, again, this is a point of departure between the small claims courts and the micro and small enterprises, because you can clearly see that the small claims courts would not have jurisdiction to entertain matters relating to compliance with terms and conditions of allocation of work sites. The other one is in relation to election and management of the associations, so that where the micro and small enterprises, as well as associations, and fail to comply with their own rules relating to election management and leadership, then the jurisdiction of the tribunal can be invoked. We also have issues relating to the general failure to comply with the constitution or the memorandum of association of either the associations or the micro and small enterprises. So to that extent, therefore, the tribunal will have jurisdiction. Issues relating to illegal as well as and procedural subdivision and allocation of the micro enterprises work sites. Those are the issues that can be presented before the tribunal, as well as issues relating to management, mismanagement and misallocation of resources. So these are the issues that can be presented before the tribunal. Now, insofar as the appellate jurisdiction is concerned, in situations where there is an administrative overreach, insofar as the functions of the registrar of the micro enterprises, as well as the functions of the chief executive officer of the micro and small enterprises is concerned, where the associations or micro and small enterprises are aggrieved by the decisions, the administrative decisions of the registrar, as well as the chief executive of the micro and small enterprises, they can appeal to the micro and small enterprises tribunal. So to that extent, therefore, you can see that the jurisdiction of the tribunal is quite vast. We have regional jurisdiction as well as appellate jurisdiction. Now, but that doesn't mean that our decisions are not subject to the appellate process. So indeed, it is actually possible for the persons who are aggrieved by the decisions of the tribunal to appeal to the High Court. And that is provided for within the Micro and Small Enterprises Act. Now, there is an issue that we've encountered insofar as the appellate mechanism is concerned, in the sense that there is no clarity as to the specific division of the High Court that the decisions of the Micro and Small Enterprises Tribunal would lie. We've had instances where a matter has been presented before the Civil Division, but we've also had an instance where the appeal has been presented before the Commercial Division. And I think those are the only two instances when appeals have been made against the decision of the tribunal. One as a ruling, and in the second instance from the judgment of the tribunal. So that is it insofar as the jurisdiction of the tribunal is concerned. Thank you.
Thank you very much, Dr. Bell. Mr. Raphael Lombua, please give us a brief history on your jurisdiction of the Legal Education Appeals Tribunal. Thank you.
The tribunal deals with the appeals regarding any matters arising under the Legal Education Act, and the matters that arise under the Legal Education Act range from matters of admission qualifications to legal education programs, matters of licensing of legal education providers, matters of progression in the field of legal education, and matters of progression actually, and then decisions on revocation of licenses, denial of licenses to legal education providers. The tribunal also deals with references made to it by the Council for Legal Education. In terms of exercise of the jurisdiction by Section 31 of the Act, it is an inquisitorial approach by the tribunal, whereby an inquiry is carried out on the matter and a finding is made. In terms of time limits, for appeals which concern licensing and decisions on licensing, those ones must strictly be filed within a period of 30 days from when one is notified of the decision taken by the council. For the other appeals, there is no time limit set. However, we believe one must act with reasonable diligence in pursuing his or her rights. In terms of the relief that can be granted, the tribunal has the powers to make the same decision that the decision maker has taken. The tribunal, in hearing an appeal, has powers to summon witnesses, order production of books and records, and it's accorded similar powers to a judge of the High Court while exercising the court's mandate. On admissibility of evidence, the tribunal is granted leeway to accept evidence that would not meet at times even the test of the Evidence Act in terms of admissibility. The most important consideration would be relevance to the question. Should one be aggrieved by the decision of the tribunal, the right of appeal is limited to matters of law only, based on the establishing statute. The tribunal normally seems to be the final point in terms of evidential questions and facts. In terms of the other powers of the tribunal, once you with it, the status quo of the matter is to be maintained. What this means is that assuming you operating a learning institution, the appeal operates as a stay until it's determined so that you can continue carrying out your operations. A debate has arisen as to what status quo would mean in terms of an applicant who has been denied admission to an education, a legal education program. It is not an easy question because it can be interpreted to mean that the learner is shut out, but the tribunal has resolved that by expeditious disposal of such disputes. I believe that is all.
Thank you very much, Mr. Wambua. And from your last comment, I'm sure you have received so many complaints from students, especially international students whom they did law here in Kenya, but they were denied to pursue Kenya School of Law, the advocates training program, because they're not Kenyan citizens. How many cases have you dealt with on such manner?
This year alone, we have registered 33 appeals dealing with the matters of denial of admission, withdrawal of admission upon it being granted when a student has reported to the school and even after they have paid school fees, non-recognition of undergraduate qualifications from foreign countries, disputes on equation, disputes on non-recognition of progression as one of the means of accessing the advocates training program.
Thank you very much, Ms. Jamato. The reason I called you last is because we have so many questions concerning the jurisdiction of the Energy and Petroleum Tribunal. As we all know, at the moment, the country is at crisis, where today we woke up and now the subsidy of the fuel that the former government had put forth, it is no longer there, so the fuel has increased. So as you're discussing and enlightening us about the jurisdiction of the Energy and Petroleum Tribunal, please also enlighten if it deals, this is a question from one of the members, Ms. Priscilla Kyoko. She's asking if the tribunal deals or has the jurisdiction to lower the prices of fuel, and also if it can approach to deal with issues to do with KPLC, or there's a certain limitation. And also from Kevin Oriri, as you're discussing on the issue of jurisdiction, please enlighten us, because the Act does not clearly define who a licensee and a third party are for the purposes of invoking your original jurisdiction. Thank you.
Okay. So I'll take a bit of some time on this issue, because it's a challenge that we have also noted at the tribunal. We have so far referred over 9 matters that had been filed under certificate of urgency, and we referred them back to the authority because we did not have a jurisdiction. So I will spend a bit of time to let you understand the jurisdiction of the tribunal, and so that we are all on the same page. And after this session, we'll be comfortable enough to file our necessary pleadings before the tribunal, so that you don't go through the whole process of wasting your time preparing very good pleadings, but ending up being referred to the authority. So to start off, we don't have a pecuniary limit, okay? So we have received matters whose pecuniary limit are as low as 20,000, 30,000, and they can range to as high as 3 trillion Kenya shillings. So we don't have a pecuniary limit. So our jurisdiction is drawn from section 36 of the Act, and I will go section by section so that we each understand the jurisdiction of the tribunal. And I need to start by saying, for you to appreciate where your matter lies, or where the nature of what is the nature of your dispute, you need to look at what section 1 of the Energy Act addresses, and section 2 on definitions, and that was properly pointed out by one of our members who wanted to know the definition of a licensee, the definition of a third party, the definition of a consumer, and what have you. So just to correct one of the members, the definition of a licensee is actually provided in the Act. It is that person who gets a license from a licensing authority. So an example of a licensee is Kenya Power. They've been given a license by the regulator, who is the authority, that is EPRA. Then you have another licensee, someone like KenGen, Ketraco, GDC, all those have licenses issued to them for purposes of doing the business or the mandate for which they were created for. Then the licensing authority could be the authority, which is the Energy, Petroleum and Regulatory Authority. It can be the cabinet secretary in charge of energy. It can be the cabinet secretary in charge of petroleum. It can be the county government. It can be an adjudicating officer, depending on what the Act provides and depending on the nature of the dispute in question. Yes, a consumer is also provided. The definition of a consumer is provided under the Act, and a consumer is now the person who enjoys the service that is being provided by a licensee, okay? Then what is not defined by the Act is who is a third party. So I will challenge the members who are present here to go and read our decision in appeal number E003 of 2022. That is the Joyce Deche case. We have defined who a third party is. We have defined who is a licensee, and we have also defined who is a consumer. Now, once you get to read and understand that particular case, you will get to know that we do not have jurisdiction to handle complaints against Kenya Power, okay? We don't have jurisdiction to handle complaints against Kenya Power. And when I say we don't have jurisdiction, I mean we don't have original civil jurisdiction to handle any complaint or any dispute against Kenya Power, okay? So let's go step by step. Let's start by looking at what is our jurisdiction. So the Energy Tribunal has jurisdiction under two acts. So we have jurisdiction under the Energy Act, and we draw our jurisdiction under the Energy Act, and we draw our jurisdiction under the Petroleum Act. Under the Energy Act, our jurisdiction is under Section 36. Section 36 has been divided into 5 parts. So the first part, it tells you that we handle all matters that have been referred to the Energy Tribunal, and these matters are related to the energy and petroleum sector. So Section 1 is a referral. We hear matters that are referred to the Energy and Petroleum Tribunal. Matters from High Court, we consider them referrals, okay? A matter that is related to probably energy sector, and the judge gets to know that this matter, he doesn't have jurisdiction, he refers it to the Energy and Petroleum Tribunal. We'll hear them. We also have matters that have been referred to us from the magistrate's court. We also have matters that have been referred to us from the authority. We have matters that have been referred to us from different institutions. So this is where Section 36(1) applies. Section 36(2) makes reference to the fact that we don't have jurisdiction on criminal matters. We don't entertain any matter that will lead to punishment or relates to criminal action. So we don't have jurisdiction on that. Section 36(3) makes reference to our original civil jurisdiction. Our original civil jurisdiction relates to disputes touching on a licensee as against a third party, or licensees that have a dispute amongst themselves. So a licensee as against a third party could mean a dispute touching on probably, say, a licensee's Kenya Power. Then the consumer is the person enjoying the electricity that is being supplied by Kenya Power. Then a third party could be somebody who is just passing along where Kenya Power is providing that particular service or is distributing that power and gets to be injured. Let's say, for example, they get electrocuted. A third party means I am not subject to the contract that you have between the licensee and the consumer. I am outside that relationship. So I now fall under this definition of a third party, okay? I hope that is clear. A third party could also mean whereby you have given access probably to a licensee like Ketraco to put up way lifts or to get right of way to put up whatever it is that they want to put up for purposes of conducting their mandate, and they end up interfering with your property, or they destroy some of the properties or trees or whatever that has been constructed or put up in your property. You are also within the definition of a third party because you're not within that relationship of a licensee and the person who is benefiting from the contract between the licensee and the consumer, or the person who is defined within that contractual arrangement. Okay. Then a dispute between two licensees, it could mean a dispute between, say, KenGen and Kenya Power. KenGen generates the power, gives it to Kenya Power fails to pay, and what have you. So a dispute between those two licensees, then we have that original jurisdiction. So anything outside that, we don't have jurisdiction. Then the last the jurisdiction that we have is that we have the appellate jurisdiction over the decisions of the authority. And the decisions of the authority could be, you have filed a complaint with the energy and petroleum regulator, that is, we call them the regulator or the authority, and they have failed to give you a decision, or they have given you a decision. If you are not happy, or if you are happy with that decision, or there's inaction by the authority, then you come to us or by way of appeal. So those are the 1, 2, 3, 4 instances where we draw our jurisdiction. So I will now just go, I think I'm clear on section 36(3). And in relation to that, it is we also have section 117(3) under the Petroleum Act. We only have original civil jurisdiction on disputes touching on two licensees, or a dispute between a licensee and a third party. That is under section 36(3) as far as the Energy Act is concerned. As far as the Petroleum Act is concerned, we have civil original jurisdiction under section 117(3), where it is a dispute between two licensees, or a dispute between a licensee and a third party on matters that are touching on midstream and downstream petroleum operations. So that is the only time we have original jurisdiction. So how do you move the tribunal, the Energy Tribunal, in an appellate process? So you can move the Energy Tribunal, as I said earlier, either under the Energy Act or under the Petroleum Act, depending on the nature of your dispute. The first one is you can file an appeal against the decision of the regulator. But this appeal, if you have a decision from the regulator, you must lodge your appeal within 30 days from the date of receipt of that decision. The regulator, on the other hand, also has only 60 days to hear your appeal. So if you to hear your complaint. So if you file a complaint with the regulator and they don't hear your matter within 60 days, you can come now directly to the tribunal and claim that you filed a complaint with the regulator and they failed to give you a ruling or a decision within 60 days, then it's at that point that we have jurisdiction. Now, the catch in this is that if the regulator fails to hear your complaint within 60 days, you only have 7 days to approach the tribunal, okay? So that is where now you can file your appeal. So in the first decision, if the regulator has heard you but has failed to give you a decision, you must come within but has failed to give you a decision, must come within 7 days. If they give you a decision and you're not happy with it, you're aggrieved by that decision, you must approach the tribunal within 30 days. That's under section 36(4). Now, what if you are not happy with the decision of the cabinet secretary? There are instances under section 87 where it's the cabinet secretary that makes decisions on matters touching on geothermal licenses. So if you're not happy with the decision of the cabinet secretary to deny, grant, revoke, suspend a license touching on geothermal, then you can also appeal to the tribunal within 30 days, okay? So that's another procedure where you can move the tribunal. Then under section 197, we have matters that are touching on energy efficiency and conservation. So energy efficiency and conservation, this is a responsibility that has been given to adjudicating officers at the county level and in some instances at the national level, okay? So if you're not happy with the decision of the adjudicating officer on decisions touching on energy efficiency, and when we're talking about energy efficiency, it's at that point where they're looking at whether you have installed solar panels, if you're putting up a very big building and things like that. and you're trying to get licenses and you don't get it, then you can challenge those decisions to the tribunal directly within 30 days. So that is the appeal process under the Energy Act. The appeal process under the Petroleum Act, you can move the tribunal under Section 1810. This is when you're not happy with the award that has been given, either when you're doing bidding rounds and direct negotiations. This is a bit complex. Of course, people who are in the petroleum sector would understand this. It's in relation to drilling of the wells for purposes of getting fuel and whatnot. They kind of go through the process of bidding rounds and direct negotiations. So the award that is given to a successful bidder, you can, if you're not happy with it, you can challenge it to the tribunal. And of course, you have to do it within 30 days. So it's also an appeal. Then under Section 78(6) also of the Petroleum Act, you can challenge the decision of a licensing authority, okay? And a licensing authority here could mean the Energy Petroleum Regulatory Authority, and it also could mean the county government. What licenses are we talking about? These licenses could include the licenses that are given to petrol stations, yeah? Those licenses are to be given by county governments. I hope we are learning as we go along, because this is as a field I have noticed many lawyers have not interrogated or not tried to get, tried not to, read into it, but they have very good opportunities for lawyers. So if you get clients who are not happy with the decisions of the county governments or the decision of, any licensing authority, including the EPRA, you can now approach the tribunal challenging the decision of that licensing authority. And the decisions from the authority are many. We have had a recent dispute where the authority suspended the license of a transporter of fuel. The tanker had gotten into an accident. I think we all got to know the accident that happened, I think, on the Mau Narok Road. There was a tanker that fell and exploded. The authority suspended that license. So we have jurisdiction to hear those matters, and we had that particular matter. Then we also have jurisdiction to hear matters touching on the decisions by the licensing authority in respect to midstream and downstream petroleum operations. So, and that is under Section 85. So the long and short of it is that is purely the jurisdiction of the tribunal. We don't entertain matters that come directly from a consumer who wants to challenge his bill. And we've had a lot of these matters that have been filed at the tribunal, and we discourage them by referring the matters to the authority. So if your client comes and they have an exaggerated bill and they claim that my meter was wrong or the meter was faulty, I request you to have a time and interact with the Energy Act, in particular Section 159 of the Act. The jurisdiction touching on metering and what have you lies with the authority. But of course, before you go with the authority, you start by filing a complaint with the Kenya Power. They have an internal dispute resolution mechanism within the organization. If that complaint is not resolved within that space, you go to the authority. And many a times, advocates have come to us complaining that they can't get interim orders at EPRA with the authority. We wish to guide you. Look at Section 11, okay, Section 11F. The authority has the powers to issue orders that prohibit the Kenya Power from, cutting off your electricity supply. And you can also try to look at the Act where there's kind of an automatic stay if you file a complaint with the authority. So just interact with the Act. You will see a lot of very good things with the Act, but don't rush to the tribunal. We have seen very beautiful, as I've said, we've seen very beautiful pleadings. And unfortunately, we've been forced to down our tools, even when we are forced to do so suo motu, because and we've asked advocates to try and interact with the Act. We don't have that direct, interaction as far as jurisdiction is concerned on a dispute. There are several layers that you need to deal with. And I hope my lengthy presentation has answered the question on jurisdiction. Yes, we do have jurisdiction to, not to lower the fuel price per se, but we are currently dealing with another matter as well, touching on fuel prices. We interrogate the formula that has been used by the authority, okay? So if we look at the formula that was used by the authority at arriving at the price at which they have now, published as the retail price at the pump level. So that is the appeal process that we deal with. So yes, if that formula has certain issues that may affect the price in terms of lowering or increasing it, yes, we do have jurisdiction to entertain that. And I thank you.
Again, Ms. Jamato, thank you. It was quite elusive. And does that mean at the moment, the government can no longer sustain the subsidy of the petroleum? So like how the now Senator of Busia County will go on behalf of Wanjiku and present such matters? Can we have such a matter presented before your tribunal?
Of course, generally for us, you see, it has to be a matter that touches on the energy and petroleum sector. So what is the nature of the dispute? If the nature of the dispute is constitutional and human rights kind of dispute, then of course we do not have jurisdiction. And I have seen quite a number of the advocates who are appearing before us can tend to, mix up, or it's not a good word to use, but we need to diffuse or try to understand the nature of the disputes that we handle. Basically, the dispute must really be on the technical aspects of the energy and petroleum sector, okay? So you'll be talking about the formula that was used was not right. Probably this formula did not take into account the landing cost, it did not take into account this particular taxation, it did not take into account this particular price. And we've had those disputes coming before us. It did not take into account probably some negotiations that they usually have, which are very technical, okay? So if you bring a matter that is a borderline human rights, or rather is human rights centered or focused, then we will not hear you, because that is not our jurisdiction. We are not here to, we do not have those powers to now get and clothe ourselves with the right to entertain. And by the way, the Constitution actually doesn't give us that right, because that will now fall under the Bill of Rights, and we do not have that jurisdiction to look at such rights, yeah? So ours is specifically the specialized nature touching on the technical aspects of the energy and petroleum sector. So, and that's why we have engineers amongst us. So if you start telling them about human rights, you will lose them completely, because they would not understand where that is coming from. They want to hear numbers, they want to hear formulas, they want to hear, things that are well outside that framework of subsidies, my rights, my goods, and whatnot. So we might not be able to look at that. So they look at the kilometers that we are looking at from the pump to the station to the, things like, it's a more complex dispute, and it is not on the face value of it in terms of me as a Kenyan, as a citizen, and whatnot. Yeah.
Thank you very much. I can see your tribunal has inversed the O2 principle. Your technical issues and the other advocate's technical issue quite different.
For us, we thank God that we blend well and we gel very well. And where sometimes the two conflict, we have always found a way where to create that balance. And of course, the law has really helped us as far as the Energy Act is concerned and the regulations are concerned, to guide our pathway and also to guide our mandate. So that has really helped us a lot to know what we can handle and what it is that we can't handle. The Act has been very comprehensive, and that's why you will see a lot of times most of the disputes must first go to the authority, because it is at that point that they will go to the very technical nature of it, where they will request for a lot of documentation. And it is at that point that they prefer you deal with the matter at the authority. Then we can now come at the appeal stage to look at what exactly it is that they may have left out, and then we will deal with it at the appeal stage. Thank you.
Thank you. A follow-up question before we let you pen down. On the same issue of Wanjiku, Bernard James Deda is asking, can the tribunal dismiss a formula, since you've discussed that you guys have to look at the numbers, the formula, and the figures? So can the tribunal dismiss a formula as bad and formulate another good formula if the tribunal is moved by Wanjiku?
It's not possible for a formula. I don't know how Wanjiku will design a formula, yeah, so for us to now come and dismiss it. What I have experienced before the tribunal is that we have had disputes where most of the appellants are OPEC, which are oil producing companies, that would come and say, this is a particular formula that we had agreed shall be applied. Yeah? So parties would now say, there's a certain aspect of that formula, an aspect of that formula that they do not agree with and would want us to relook at or relook into it and now just have a second bite of the cherry. So more often than not, we may not interfere with the formula. You can look at how probably it could be improved, or how parties can be taken back to negotiations, and which is something that we really encourage. Negotiations has really helped, because the Energy and Petroleum Tribunal is also a tribunal that takes into account that a decision that we make can bring down an economy. Yeah, you can decide that today we are removing a formula and putting Wanjiku's formula, but you end up killing the economy, because you will chase away the oil marketers, and they might not be able to sell the fuel to you. So it is a balancing act that you must have in place, so that you ensure that it's fair to the regulator, who is trying to ensure that Wanjiku can afford it. And that's what people need to understand, that the regulator is there to ensure that Wanjiku can actually access that fuel. Because if the regulator was not there, then the oil marketers would have been having a free for all. And right now, prices would have been extremely high, where you could not afford it. So there's that balancing act that you need to come up with. And I believe chances are very rare that parties would not want to sit down to negotiate. And we encourage a lot of out of tribunal negotiation.
Thank you very much for that much needed info. Lastly, will you mind shedding some light on way leave agreements? That is from Karuga Mugo.
Unfortunately, I can't. We have 2 live matters that are touching on way leaves. I would just encourage parties and members to look at sections 170 to 189. Look at what they provide. They're actually very clear and on agreements and way leaves, and how do you go about it? What are the procedures if there is a dispute, and what have you? The reason as to why I cannot address the matter is because it's very live, and in fact we are working on the decision. Parties have been told to put in submissions. So unfortunately, I may not be able to comment on that particular aspect. And but I encourage you to just look at sections 170 to 189 of the Act. Thank you.
Thank you very much, Ms. Jamato. That was very much needed. This question is posed to both Dr. Bet and Mr. Wambua by Anna Omwega. Please clarify on the 2 advocates who should be members of your said tribunal as experts, and how many years standing. And as you're answering that, she insists on please interpret on the term expert in this context. Let's start with Dr. Bet.
Thank you. So to answer our sister there, Anne, when you look at the provisions of the Micro and Small Enterprises Act, it provides for the 2 advocates who should be members of the tribunal. And the Act has not prescribed the years in terms of experience, because it provides that there should be 2 advocates with expertise in micro and small enterprises matters, one of whom shall be the secretary, and both of them are appointed by the cabinet secretary. So the Act has not specified, the number of years that the 2 advocates should have. But
what is the common practice?
Yeah, the current holders, I think you would allow me to disclose this. I think they have 13 years and 24 years, respectively, as advocates. Now, on matters relating to expertise, I think this is a matter that can be determined by the appointing authority. And in this particular case, it is the cabinet secretary. Again, the provisions of the Micro and Small Enterprises Act has not given indications as to whether these 2 advocates should be nominated by the Judicial Service Commission and appointed by the cabinet secretary. But in relation to the chair and the vice chair, there is clarity that the nomination is by the Judicial Service Commission and appointment has to be done by the cabinet secretary. But for the 2 advocates, the law is silent insofar as nomination is concerned. But the general practice has been that the cabinet secretary, and I think this is the practice that we've had, is that the cabinet secretary appoints these 2 advocates. Now, there is, we also have a category that is an advocate representing the Law Society of Kenya. And when you look at the Act, there is clarity that the level of experience is not less than 7 years. Of course, nominated by the Law Society of Kenya and appointed by the cabinet secretary. So that is it insofar as the status of the 2 advocates is concerned. Sorry, there was another question.
Thank you. Yeah, it was mostly on to define what is expertise in this context and the number of experience which you have elucidated very clearly that it is within the whim of the CS. Thank you. Mr. Wambua, on the same question.
For the tribunal, there is no requirement to have 2 advocates as experts. In fact, all the members and chairperson are legal practitioners. Their experience ranging from 18 years of legal practice to over 20 years. 2 of the members have been teaching law for a long time, one at the Kenya School of Law, and the other one has been teaching at the university. All that matters is, based on the Act, is the demonstration of competence in the field of law and academia, and even the statutory experience that has been set has been well surpassed by all the members and the chairperson of the tribunal. Everybody is ranging between 18 to over 20 years of legal practice teaching.
Thank you, Mr. Wambua. And you have mentioned that most of the members, the lawyers members who are in the tribunal, their ages of experience is from 18 and above. Is it statutory provided or is it arbitrary from the CS?
The statutory limit for the chairperson is 10 years of legal practice. For the member in category 1, 7 years. For the other members, they ought to demonstrate competence of 5 years. But the tribunal surpassed that limit even at the time of its being constituted by the Judicial Service Commission.
Thank you very much. This question is for the three of you. I will start with Dr. Beth. Karugo Mugo asked if the tribunal adopt ADR mechanism in dispute resolution. Dr. Beth, does your tribunal adopt ADR as stipulated by
Yes.
Article 159? Do you encourage it to your members?
Yes, indeed. We have members who are mediators in our tribunal, and we do encourage ADR mechanisms. A number of times we've deployed, mediation, and in our experience, we've realized that in situations where we've adopted ADR mechanisms, we've been able to dispense with matters within the shortest time possible. So yes, we do encourage mediation. Sorry, not mediation, but alternative dispute resolution mechanisms generally.
Thank you very much, Dr. Beth. As Mr. Wambua is answering, I'm requesting Ms. Jamato to please, you can send on the chat the case number that you told us on to define who is a third party and who is a licensee. So, Mr. Wambua, does your tribunal encourage ADR?
The formation of the Legal Education Act does not seem to contemplate alternative dispute resolution. However, based on the provisions of Article 159 of the Constitution, ADR is to be encouraged. The tribunal, in its rules, is seeking to address that matter. However, we have never had a request for ADR by any of the parties for purposes of referral. However, when it comes up, the tribunal would consider it for purpose of expediting justice.
Thank you very much, Mr. Wambua. You've mentioned how your tribunal works hand in hand with so many experts. In terms of access to justice, does it also encourage ADR? Ms. Jamator, can you hear me?
Yes, I can hear you. Please go again.
I was saying, in your previous submission, you've highlighted how your tribunal work hand in hand with so many experts. And I'm also asking in the same line of access to justice, does it encourage ADR on the matters that are filed before you?
Yeah, in as much as we have experts amongst us, we have two experts in matters energy. Actually, everyone who is, most of the members of the tribunal are experts in their respective fields. It's just that we have, I hope I'm not breaking.
No, you're clear. I can hear you very well.
Okay. So the seven of us actually have experience in matters energy and petroleum. It's just that the two engineers are experts in the field of energy and specifically, what is it called? Electrical engineering. We do encourage mediation, to be specific, especially on matters that are considered high profile. And we are grateful that more often than not, the parties have, on their own initiative, requested the tribunal to try and resolve the matter outside the confines of the tribunal. And we have encouraged them to do that. On these other matters that where we have original jurisdiction, unfortunately, We have not yet had a dispute between licensees, and if at all, if it is there, then we would also encourage it. But I can also tell you that it is in our draft rules of procedure. We are going to have a specific rule on the process of ADR and how to initiate the ADR mechanism. So we have fully embraced it, and we are actually implementing it as well. Thank you.
Thank you very much, Ms. Jamato. Finally, Mr. Wambua, what opportunities lie before your tribunal that advocates can actually take it up?
There is a vacancy for one member, which is there. It has been there for a while. After one of the members left the tribunal, that is an opportunity that can be taken.
Mr. Wambua, in the same line of question, do you do training to all these? Do you do any training that you can require advocates?
The tribunal as a dispute resolution point rarely does training. However, it has its many seminars and conferences that it holds, and at times it calls in practitioners to attend, and also not only legal practitioners, there are many other practitioners that the tribunal invites at such sessions.
Thank you very much, Mr. Wambua. Dr. Jackson Bett, which opportunities lie there in your tribunal for advocates?
Well, I think the very first opportunity is the fact that advocates can earn their fee within the shortest time possible. I think that is a grand opportunity. But we also have instances when in our training sessions, we've invited advocates to help us in capacity building. But in terms of, because my colleague has mentioned, the opportunity within the tribunal, allow me also to mention that we currently have a vacancy for LSK representative. Our former representative joined judiciary, family, mainstream as a judge. So currently we have a vacancy of a representative of the Law Society of Kenya.
Thank you very much, members. You've heard it. There are two vacancies already out there, one at the Legal Education Appeals Tribunal and another one at the Micro and Small Enterprises Tribunal. Thank you. Ms. Jamato, any opportunities for advocates in your tribunal?
Well, we are full house, so unfortunately not. And but the opportunities are many. I have realized that lawyers have not interacted with the energy and petroleum sector very well. If you get to read this act, you will get to see that there are very many opportunities. This tribunal would end up being a very busy tribunal if lawyers could get out of the mainstream courts and just come to the tribunal to deal with the matters that are touching on the energy and petroleum sector. Why do I say this? Is that I have seen very many lawyers are quick to rush to court or to even our tribunal just to get that order of injunction, which, as I've said, is not the right procedure. You would get many opportunities if you actually filed the complaints at the licensee's office, and their failure to on it, gives you another opportunity to go and lodge an appeal to EPRA. If EPRA doesn't deal with it, you get another second bite of the cherry with the tribunal, okay? So then we also have very many opportunities at the county level. We need to understand the roles of the county government as far as energy efficiency and conservation is concerned, what are their roles in as far as licensing is concerned. Then you get to help the mwananchi in addressing the challenges that they face in the energy sector. And I think I, from this position, feel like we have not played that role very well. And we have the power of this act, which has given us a lot of power to address the many issues and illegalities that are happening around this sector. And if lawyers could just take it up and be proactive, you can even be an omotata and take up matters against county governments or a licensee or what have you, where there's breach of sections within the act, and it will open up very many opportunities for you as a practitioner. But yes, there are very many opportunities that I have seen that have not been taken up by council, and I challenge them to get into it. And I think it pays very well. It's a sector. If you look at the fines that are charged on a licensee or an entity that fails to comply, one of the fines of failing to comply with an order by the regulator is that you'll be charged 100,000 a day for failing to comply with an order by the regulator. Yes, that is under the Energy Act. And if you fail to comply with the order by the authority under the Petroleum Act, it is 500,000 a day. So you see, those are very good opportunities that are out there that people have not looked at. They've not interrogated the act. And we are yet to see who wants to run and just look for someone to, And of course, the energy sector is just going on as though people are scared. I don't know that they're scared or it's lack of knowledge, but I hope the branch, since you've come up with this session, it will enlighten our members and they will be challenged to take up the brief and mantle to look at opportunities where they can represent their clients. Yes, thank you.
Thank you very much, Ms. Jamator. And we personally have been challenged by all the 3 tribunals. I need to reread all of them, refresh my knowledge on them, and see the opportunities that I can come and tap in them. Yeah.
Teresia, would you allow me? Teresia, would you allow me? Yeah, please allow me also to mention.
Yes, Dr.
That for a long time we didn't have a fully operational office of the registrar of the micro and small enterprises. But in the year 2020, that office was operationalized towards the end of the year 2020. And as it is now, it should be possible for members of the legal profession to engage the office of the registrar of the micro and small enterprises. Thank you.
Thank you very much, Dr. Bet. Members, you've heard for yourselves. Yeah, I hope all of us are coming out here knowing that we have been lying to ourselves that it's all about litigation and just boardroom commercial transactions. At the tribunals, they lay so many opportunities for us, and which are going to be expedited within a period of just 2 months, or not more than even 6 months. While when you go to the High Court or start doing a corporate matter, it can even last us 3 or even 5 years. So let's take up this challenge. Let's revise let's go back and revise on these acts that give the mandate to this tribunal so that we may be able to scope and analyze and see what opportunities that we can come up with. And most above all, let us interact with our tribunal members so that we can see how we can tap into their tribunals. So lastly, I'm going to ask the panelists to give us their location so that once we have perused and we have seen what we can do regarding the tribunal, we'll be able to come to your offices. So I will start with Dr. Jackson Bet. So where can we find you? Where is the tribunal located, the address? And if you don't mind, once you finish telling us where it's located, you can also write down on the chat section so that members can be able to get the info very, thank you.
Okay. Yeah, thank you very much. So we are located in Forodha House, 4th floor. And we have 2 emails that I will share with you shortly in our chat platform. I will also share with you the phone numbers that can be used to reach the tribunal. Thank you.
Thank you very much, Dr. Beth. Yes, Mr. Wambua, where can we get you? Where is your location? Any email address? And please, after you tell us in passive, also write it down on the chat so that members can have the same.
The tribunal is located at
Mr. Wambua?
House. The tribunal is located at Forodha House in the city of Nairobi, 4th floor. The secretariat is there. We have an operational email and a telephone number. I'll be able to post them in the chat.
Thank you very much, Mr. Wambua. Ms. Jamato, I can see that you've already sent us via the chat.
Yeah, that's our email for purposes of sending communication to the tribunal. We are also located at Forodha House at 4th floor. I think that's where the office of the Registrar of Tribunals is, and that's for most tribunals that have transitioned to the judiciary. That is where we are located, and our secretariat are also located there. We also, but as a tribunal, we sit at Kawi House in South Sea, ground floor, but that is for purposes of just conducting the mainstream, not mainstream, our mainstream business is just adjudicating disputes, but the other disputes that now, the other issues that touch on administration of the tribunal and governance, we do sit at Kawi House, but we are always at Forodha. All our documents, as I said, we file them online and we pay our fees online and we hear parties online. Thank you.
Thank you very much, Ms. Jamato. I want to take this opportunity to thank you all the panelists for the time that you've created to join us, to give us your info, and more so even our members like Rahab Mwati, Anna Mwenga, Karugo Mugo, they've also relayed their gratitude because it was quite an enlightening session. We have learned a lot. And members, I will tell you, it's not the first time we are holding this Know Your Tribunal series. We have almost 22 tribunals in this country, and this is the 4th series. Every month, we always host one Know Your Tribunal series where we bring in 3 members or 3 chairpersons of those tribunals to be able to give you an idea of what happens, not just in the court division, but also in the tribunal. At the end of the day, it's all about our bread and butter. And at this juncture, I want to call upon our panelists to give us their final remarks. I will start with Miss Dorothy Jamato.
Oh, thank you. First of all, thank you for having us. And I think and I pray that our members will spread the gospel because this is also one of the ways we've realized that we can solve some of the challenges that we are experiencing. And as I mentioned before, we've been referring quite a number of matters, which was a concern to us. It meant that our members did not understand our jurisdiction. And I hope that the members who've attended today's session will spread the gospel, including the branch itself, so that you can have probably an abridged version of what the jurisdiction of the tribunals are, so that people, our members will have a better understanding and appreciation of our jurisdiction and our mandate. But to the members who have stayed throughout the 2 hours of listening to our very beautiful voices, I thank you for sacrificing your time. And I hope we have broadened your way of thinking and scope. And for any help, clarifications, just send an email. We are a phone call away or an email away, and we will guide you through that entire path and process. I thank you, Teresia. It was a wonderful session.
Thank you very much, Ms. Jamato. It was a pleasure having you as well. We've learned so much. Mr. Wambua, your final remarks.
On behalf of the tribunal, we first wish to thank the Nairobi Law Society for organizing the session. At least we have been able to shed some light about the operations of the tribunal. We have also been able to receive good questions from the members who have attended. I would also like to thank them for their patience of having to listen to us for all those hours. Thank you.
Thank you very much, Mr. Raphael, for accepting our invite and for enlightening us a lot of the Legal Education Appeals Tribunal. The floor is yours now, Dr. Jackson Bett. Your final remarks.
Okay. Thank you very much, Teresia. First of all, I wish to thank the organizers of this series. I think we've really learned a lot. Personally, I've learned a lot from the Energy Tribunal and the Late Tribunal. So we believe that the blueprint by the Honorable Chief Justice of the Republic of Kenya would be realized, if we have, a full scope in terms of access to these tribunals, especially the Micro and Small Enterprises Tribunal, because of the numerous opportunities that we've seen, and you can clearly see that we try as much as possible to reach the common mwananchi. So we really hope that that transformation would be achieved sooner or later. So to the members of the Law Society of Kenya, we are waiting for you at the tribunal. Thank you very much.
Thank you very much, Dr. Bett, and do not threaten us because we will flock in your tribunal.
You're welcome.
Anyway, members, thank you for coming. Thank you for attending. Thank you for your patience. I can see one member, Philip Ongodi, wondering how he has missed the last session. Please make sure every time the branch sends out info, you always read it through so that you can see what is happening. We have so much planned at the branch, and above all, we appreciate you for giving us this opportunity to serve you and to make sure that you are all in the know on what is happening in the legal section in this Nairobi branch. I want to thank you also for our secretariat for hosting us, and all the panelists and all the 42 members we started with, and now we are number 26. As you're all going to your different perspective of jobs or maybe going home because it's almost 4:30, I want to wish you a very lovely evening and may God bless you. Before I leave, someone has asked a question, that is Karugo, when will the decision on the petroleum prices be released? Ms. Jamato, I know we have closed the session, but there's a member who's itching to know something. When will the decision on the petroleum prices be released?
Oh, we don't have a matter. We only have one. It's a dispute touching on the petroleum prices for marketers in Samburu County. So, and that matter has gone for mediation, and probably now it has been overtaken by events, but the matter is undergoing mediation. We do not have a matter currently before us challenging the petroleum prices. I hope I have answered this question, but I am not aware of any matter that has been filed challenging the current prices that were published yesterday. Is it today?
Okay, thank you very much, Ms. Jamato. Mr. Karuga Mugo, I hope your question has been well answered. If not, you have the opportunity to take the floor to seek clarity. Mr. Karugo? Yeah, it seems like you have answered. Thank you. So
Yes.
members, at this juncture, want to close the session. And I wish you all the very best and I hope to see most of you in the next Know Your Tribunal. As I mentioned earlier on, we have 22 tribunals in this country. Let us know them, let us be equipped with the knowledge about them, and above all, let us expand our areas of practice. Thank you very much and God bless you. Bye.